TCC Judgment 112, 宪判 14. Case on the recusal of judges in retrials and appeals of criminal cases. Hand notes. Article 17, subparagraph 8 of the Code of Criminal Procedure, which required judges to recuse themselves if participated in a decision at a previous trial of the same case, is constitutional. The term previous trial should be interpreted as the decision at a previous trial of a lower court, and does not include the situation where the judge had participated in a decision at a previous trial of the same instance level before being quashed. Within this perimeter, JY interpretation number 178 needs no supplementation. In situations where the retrial or extraordinary appeal judges have participated in the previous final decision of the same case, the Code of Criminal Procedure is unconstitutionally insufficient for lacking specific provision requiring the judges to recuse themselves. Article 2 of Supreme Court's Implementation Standards on the allocation of civil and criminal appeal cases quashed twice previously. Article 9, paragraph 1, subparagraphs 1 and 2 of Supreme Court's Implementation Standards on the allocation of criminal cases and the resolution of its joint meeting of presiding judges of criminal panels of the Supreme Court of 1994, which stipulated that cases that have been quashed thrice and those that concern major crimes should be assigned to the judge who previously quashed the cases on final appeal of the Supreme Court are constitutional. These provisions are internal standards stipulated by the Supreme Court under the protection of judicial autonomy and do not violate the right to judicial remedy. Supreme Court Criminal Precedent 29 Shang 3276, which ruled that the judges at the first or second instance who have participated in previous trial are allowed under Article 17, subparagraph 8 of the Criminal Code to hear the case as a retrial judge of the same level after a higher court quashed and remitted the case, is constitutional. The disputed precedent does not infringe on the defendant's interest in appeal under the right to judicial remedy. Background note. This case concerns the rules of recusal for judges in criminal procedure. When it comes to retrials, appeals against the retried cases and extraordinary appeals, there are a total of 52 petitioners in this case, 37 of whom are currently on death row. 2 of them were deceased at the time of this judgment. One of the petitioners was petitioning on behalf of his 2 brothers, executed in 2014. During the petitioner's respective criminal trials, retrials, or appeals, they were all faced with a similar situation where the judges in proceeding were the same as in the previous trial. Their situation can be classified into 3 main categories. A. Any of the retrial or extraordinary appeal judge had participated in retrial of a previous instance. B. Any of the final appeal judge is the same as the judge who previously quashed the case for retrial. This happens when the case has been quashed twice or when it concerns a major crime. C. Any of the retrial judge at the first or second instance has participated in previous trial of the same instance before higher court, quashed and remitted the case. The petitioner filed for constitutional review. Respectively, they mainly argue that by allowing judges of previous trials to participate in the cases in aforementioned situation, the following provisions and decisions are constitutionally violated. That is, it violated the principle of lawfully designation of judges, due process of law, and consequently infringe their right to a fair trial and judicial remedy. A. Article 17, subparagraph 8 of the Code of Criminal Procedure, hereinafter Code Provision 1. Article 2, Supreme Court's implementation standard on allocation of civil and criminal appeal cases quashed twice previously, hereinafter standards provision 1. 3. Article 9, paragraph 1, subparagraph 1 and 2 of the Supreme Court's implementation standard on the allocation of criminal cases, hereinafter standards provision 2-1 and standards provision 2-2. Resolution of its joint meeting of the presiding judges of criminal panels of the Supreme Court of 1994, hereinafter the Supreme Court Resolution 1994. And 5. Supreme Court Criminal Precedent 29 Shang 3276, hereinafter the Supreme Court Precedent 1940. For the same reason, the petitioners also call for JY Interpretation Number 178 to be supplemented. In addition, two of the petition number 3 and 39, lodged for constitutional review against their final criminal court decision. The petitions from 52 petitioners were consolidated. The TCC held a public hearing and summoned related party for opinions on October 24, 2022. The briefing was attended by the attorneys of 3 of the petitioners, representatives from the Supreme Court and the Criminal Department of Judicial Yuan. Summary of the judgment holding. 1. The term where the judge had participated in a decision at a previous trial in Code Provision 1 should be construed as where the appellate judge of the case had participated in the decision of the case at a previous trial of a lower court. And it does not include the situation where the judge had participated in a decision at a previous trial of the same level before being quashed. So long as the provision is construed as such, it does not violate the principle of the protection of people's right to judicial remedy under Article 16 of the Constitution. JY Interpretation Number 178 needs no supplementation or adjustment within its scope. 2. Retrial or extraordinary appeal judges should recuse themselves if they had participated previously in the final decision of the case. The Code of Criminal Procedure lacks the above-mentioned recusal provision, thus unconstitutionally violates the protection of the right to judicial remedy under Article 16 of the Constitution. The competent authority should amend the code as appropriate within a 2-year grace period. Before the amendment, newly lodged cases and cases underway should be tried according to the requirement of this judgment. 3. Standards provisions 1 and 2-1 stipulate that when a criminal case was previously appealed and quashed thrice by Supreme Court, it should be assigned to the last judge that quashed the case, and the first and later appeals to the Supreme Court. The provision do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. 4. Standard Provision 2-2. The decision of the Supreme Court Resolution 1994 provides that the quashed major crime cases should be assigned on the later appeal to the judge that quashed it. The provision and the resolution do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. 5th, the Supreme Court Precedent 1940 ruled that the situation where the retrial judge at the second instance had participated in the previous trial of the same level before a higher court quashed and remitted the case does not constitute the ground for recusal because the trial of the same level, which is different from the situation where the judge of the previous trial joined the case on appeal. The precedent does not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. 6. The petition of petitioners number 1 and petitioners number 4 to 52 are meritless and shall be dismissed. 7. In terms of the petitioner number 3's constitutional complaint, Supreme Court Criminal Order 111 Tai Kang 657 111 Tai Kang 657 is unconstitutional. It should be quashed with this matter remitted to the Supreme Court. Petitioner number 39 constitutional complaint to the Supreme Court Criminal Judgment 111 Tai Kang 2479 shall be dismissed. Nice. All of the petitioner's motion for preliminary injunction shall be dismissed.